Good afternoon. I'm Dan DeRose with 19 News, coming to you again from our digital desk. We're about to take you live to a court in Erie County. That man you see, obviously not the prosecuting attorney we've just zoomed in on, but on the other desk to the right there, the man in the plaid shirt is Robert Bors. You see him there. He is the man accused of and pleaded guilty to using a cattle prod on his 7- and 8-year-old children. He pleaded guilty in September of last year, but then all of a sudden apparently had a change of heart and had his attorney file in December that he wanted to remove his guilty plea on the use of that cattle prod. We get the all rise, and the judge here is going to basically be deciding if you can do that, if you can go back and suddenly remove your guilty plea. He pleaded guilty to 2 counts of domestic violence, a much reduced charge from what he was facing with felony child endangerment charges. Let's take a listen into court.
I got this case from a different judge. Did you guys ever fill out a form for videotaping?
Not today.
Okay.
We've covered the story before, but not
Oh,
today.
okay. But you've got, I just want to know if you've got one on file. If not, if you do, great. If you don't, then before you leave today, let's get one on file.
Okay.
That's all.
I know we did it before.
Oh, if you did it before, good. That was with the other judge.
Yeah.
Because I just got the case in August. So as long as you did, we're good.
Judge just having a conversation with our Harry Boomer to make sure that media has filed the proper paperwork to be in the courtroom, and we will make sure that happens. Let's take a listen.
On the record, in the case of State of Ohio versus Robert Bors, case 2024 CR 100. Today's the 8th day of January, 2026. Present in the courtroom is the defendant, along with his counsel, Attorney Brent English. On behalf of the State of Ohio, this is Prosecutor Paula Lilly. Victim's advocate, Ms. Sarah Reynolds. From Perkins High Academy students, we have numerous ones over there today observing through the Academy experience. Counsel had requested to have a sidebar with the court. Sidebar.
All righty, the court immediately going into a sidebar. Right there is the cattle prod in question. If you don't know what a cattle prod it is, that's about a 3-foot tool. It's used on farms, obviously with cattle. Delivers a very powerful electric shock. When we talked to the sheriff at the time, the Erie County Sheriff, they believed that this was not the first time, and it was not a single incident in which Robert Bors had used this cattle prod on his 7- and 8-year-old children. In the words of the sheriff at the time when we did the story, he said that cattle prod is intended for an 1,100-pound bull to get them to move if they're not in the right area, not intended for a 70-pound 8-year-old. So that's where we're at. Again, he was facing very serious felony charges, child endangering, child abuse charges. He pleaded down in September of last year to 2 counts of domestic violence, but all of a sudden in December decided he wanted to take that plea back out. And we're trying to see in court today if the judge will allow that to happen.
For the record, this is a hearing on motion to withdraw the guilty plea that the defendant Bors had previously entered. We began a hearing, evidentiary hearing on that motion to withdraw December 11th, 2025. It got continued until today, January 8th. And for the record, defense filed apparently a 38-page motion today, almost a month after the last hearing, and the state had just learned about it a couple of minutes ago, and they've requested time to review it before we proceed. So that's what's taking place at this time.
Your Honor, just for the record, the text of the motion is 23 pages. The remainder is just exhibits.
Okay, thank you. I have not looked at it, so thank you for clarifying that.
And for the record, it has been filed.
Today.
Yes, it was filed today. That is correct.
I'll tell you what, while we wait for the state to review this 38-page document that was just filed today, we're going to play for you the story that our Stephen Hernandez did on this case when he was initially arrested back in March of 2014. Let's take a look.
We are going to talk to him, but he is under arrest right now.
New video from the moment last week when Erie County Sheriff's deputies arrested Robert Boris. He's accused of disciplining his children with a cattle prod. It's a situation that Sheriff Paul Sigsworth can't wrap his head around.
We have a individual using a electronic cattle prod to discipline a 60-pound child that's designed to be used on an 1,100-pound bull.
The sheriff
In fact,
tells
it
us
looks
they
like we are
responded to
now
a
back in court. Let's take a listen in. Nope, and apparently still reviewing. We'll just pick that story back up where we left off.
tip from Children's Services to Boris's home near State Route 113 in Florence Township. 34-year-old Boris and his partner sound surprised with the charges.
There's 3 counts of felony domestic violence and 3 counts of child endangering. I don't know any of the circumstances, like I said.
A cattle prod is a 3-foot-long device typically used to control livestock through an electrical charge. And according to the Sheriff's Office investigations, this is not a one-time incident.
I do know that it was used more than once.
Earlier today, Boris waived his preliminary hearing at the Vermilion Municipal Court. His case now goes to the Erie County Court of Common Pleas. Boris's kids were also removed from the home the night of the arrest and are now living with other relatives as the grand jury makes its decision.
I can't imagine, what would compel someone to engage in conduct like this.
In Erie County, Stephen Hernandez, 19 News.
And we are live back in court. The state has reviewed a brand new 38-page document filed just today by Bohr's defense attorney. They need another sidebar. I'm going to guess, and we're not going to listen in here on the sidebar, I'm going to guess the state may need more time here to have a new piece of, a new document put in on the day that they're supposed to have this hearing on whether or not he can remove this charge. I have a feeling the state is going to have to ask for more time to review the new document, so we may get a continuance here. Looks like they're ending their sidebar, and we'll see what the judge decides here moving forward. Again, another complication in an already complicated case as we wait to see the decision here. You could hear from the judge, and even the defense attorney tried to get smart right back with the judge and say that this was just filed today.
Well, I just wanted to point out to you.
No,
there's
I don't
a
want to
legal
hear it.
issue.
I don't want to hear it.
That's all I was saying.
Step away.
Yes, sir.
I remind you, Mr. Boers, you're under oath.
Wow,
Civil
things
House
just got
cross-examination.
really contentious.
Mr. Boers, when you were here last and during your direct testimony, you indicated, did you not, that each time that Judge Vanette inquired of you during the plea hearing, you provided information that you're now indicating was a lie. Is that correct?
Can you say that again, please?
Sure. Each question that Judge Vanette asked you during your plea hearing, to which you said yes, for example, I understand the charges that are brought against me, your response was yes, correct?
Yes.
And that you were entering a plea voluntarily, you answered that question with the affirmative, yes, you were, correct?
Yes.
And when you said that there were no promises or representations made prior to you entering that plea, your response to Judge Vanette was that is correct. That's what you told him, correct?
Yes.
And all of the other questions, like, do you understand, do you have any questions? You were happy going through that hearing, answering in the affirmative each time Judge Burnett asked you those questions, correct?
Yes.
And when he asked you, are you guilty, you pleading guilty because you are guilty, you answered him that yes, you were. Is that correct?
That's correct, yes.
And when you testified when we were here last in December, you testified that to all of those answers that you gave Judge Burnett, you were lying. Isn't that correct?
Objection, Your Honor.
Basis,
That's not what he said at all.
rephrase.
And, Your Honor, could I?
Rephrase. I sustained it, rephrase.
Could, Your Honor, could.
No, rephrase.
I'd like to at least make a motion to separate witnesses. That's, if Mr. Maguki is in the room, and I don't know if he is.
He's not.
Okay,
I
fair enough.
know Attorney McGookie, and he's not in the courtroom. I believe there's one other witness in the courtroom for the state, either it's Mr. Valletta,
Yeah.
Deputy Valletta. He's the only witness.
Who is the state representative, yes. And he will be called to testify, Your Honor, but
Yeah,
I'd ask him, he needs to do his.
he's state's witness. Mr. McGookie's not, Attorney McGookie's not in here, so proceed, rephrase your question.
Thank you. Mr. Boers, you told the judge at your plea hearing, we already talked about you saying yes to all those questions, correct?
Yes.
But you told us last time when we were in court that when you responded to those questions, that was not an accurate response, correct?
Correct.
So in other words, you were misrepresenting to the judge your understanding of what you were doing, correct?
Correct.
So if you were lying or misrepresenting to the judge that information then, why should Judge Burnett believe anything you say in this proceeding?
May I explain?
First answer my question if you would, please.
Eh.
Why should he believe what you're saying now if you misrepresented to him the last time?
Objection, Your Honor. He was
Basis.
trying to answer that question.
Basis?
He was trying to answer that question and got cut off. I object.
Overruled. Answer the question.
What's the question again?
Sure. I said, if you made misrepresentations to Judge Burnett at your plea hearing, why should Judge Burnett believe anything you say in this hearing? I'm sorry, I can't hear you.
I'm sorry, I was talking to myself, trying to think this one through.
Oh, okay.
Because I'm being honest.
And you were not being honest during your plea hearing, is that what you're telling us?
I was going with what I knew had to be said because I was told it would be a guarantee to see my children.
And by whom were you told it was a guarantee that you would see your children?
Jonathan Maguki.
And it's your testimony that he made promises to you in advance of the plea hearing that guaranteed you would see your children?
Yes.
So when Judge Burnett, during that plea hearing, said to you, were any promises or representation made to you prior to this hearing, you said to him, no, there were not. Isn't that correct?
Yes.
And that, now you're saying that was untrue.
Yes.
You further would have said to him, is there anything in response to his question, is there anything that was said off the record that you think this court should know about now? Do you remember him saying that to you?
Honestly, no. I mean, everything happened so fast.
And did you, at that hearing, do you recall Attorney Maguki asking the court to amend your bond to allow you to have contact with the children?
Yes.
Do you recall Judge Burnett advising you that he would take that matter under advisement and issue a ruling later?
Yes.
That plea hearing was on September 15th, is that correct?
Yes.
And and in that plea hearing, Your Honor, may I approach? the
You may.
One of your exhibits, I think it's your exhibit.
Just a moment, I want to see one thing.
Thank you. Mr. Boers, I'm going to hand you what I've marked as State's Exhibit 1. I'm going to ask you to please take a look at that document.
This is first page.
If you'll flip through the whole thing, if you would, please.
If you want to sit over there, you can. You're good.
Mr. Boers, you recognize that document to be the plea sheet, the judgment entry of the plea that you entered on September 15th of 2025.
Yes.
I'd like you to look at the second to the last page of that document. If I may, let's see here, okay. And at the bottom of that, it bears your signature, does it not?
What page is it?
I'm sorry, page 5 of 6.
Thank you.
Yeah, that appears to be my signature.
Okay. Your attorney filed a motion to withdraw your plea, is that correct?
Yes.
That's why we're here. And did you review that document before it was filed with the court? The motion that was filed on your behalf?
Yes.
So if in that document or that motion it indicates that you never signed the plea sheet, that would be a misstatement, correct?
It would be correct, but I believe it said in the paper it was not on the docket.
But if the motion says you never signed the plea sheet, that would not be correct. Isn't that true?
Yes.
Because that is in fact your signature as you just attested to, correct?
Yes.
Also, as I've indicated, and you agree that the judge had a conversation on the record regarding your request that the bond be modified to allow you to see your children, correct?
Yes.
And he advised you that he would take the matter under advisement and let you know later, correct?
Yes.
Here's the actual certified copy.
Yeah, I know what it is.
You want to hang on that? You want to review, Judge? Use it. I might have some. You have some? Okay.
You're not in the States.
No, sure.
Just mark it state.
Mr. Boers, I'm now going to hand you State's Exhibit 2. If you'd like, you can set that one up here somewhere if you want, but that's fine. Mr. Boers, as you're looking at that, am I correct that it's captioned your name, the case number, and it says bond judgment entry? Is that correct?
Yes.
And that's in fact the judgment entry, is it not, that denied your request to have contact with the children? Correct?
I'm sorry, say.
Yeah, that document states Exhibit 2 is the judgment entry from Judge Burnett that says, no, I'm not amending your bond to allow you to have contact with the children, correct?
Yes.
And the date of that, please, is what? You can look at the upper right-hand corner. When was that filed by the court?
September 16th.
And I assume that Attorney Moguki, who was your attorney at the time, made you aware that the court denied your request to see the kids. Correct?
Yes, sir. Yeah.
Okay.
No, I think it was secretary that told me.
Okay, but you became aware when the court issued this order denying your request to see the children. You were told by the law firm of Jonathan Moguki, I'm sorry, Mr. Borders, the judge said, no, you can't see.
Not the day of this entry, it was probably a week or so later
Okay.
when I finally got a hold of them.
Okay. So you were able to contact, or at some point within a week or so, you learned, while still in September, that you were not going to be allowed to see the children, correct?
Correct.
So the minute that you found out that what you were trying to tell us was the promises made to you hadn't happened, you did not request your motion, your plea to be withdrawn, did you?
No, I didn't know I could.
You were arrested in October of 2025 for a violation of the conditions of your bond based upon a new charge, correct?
Correct.
You recall going back to that plea hearing again of September 15th, that Judge Burnett would have advised you that while you were awaiting sentencing, in between the plea and the sentencing hearing, if you were involved in any further criminal activity or any bond violations, that it could impact his determination of an appropriate sentence in your case. You remember having that conversation with him?
I don't fully remember all of it.
Okay. Your Honor, at this time, I've already had a conversation with Attorney English. He will stipulate to the authenticity of the plea hearing. So if I may at this time play that, and you have with me.
You may.
Okay. Yeah, in doing so, do you mind if I'm seated while you're?
Fine.
I will mark that, Your Honor, as State's Exhibit 3. And I'll indicate for the, Your Honor, for the record, in my conversations with Attorney English, he said he too has received a copy of that and had the opportunity to review it in advance of today.
That is correct, Your Honor.
Thank you.
I have one there. Yes, but I'm.
On the record in the case of State of Ohio versus Robert Boris, case 2024 CR 100. This matter is set for a final plea today. Today is September 15th of 25. President of the court remains the defendant along with his counsel, Attorney Jonathan Moguki. On behalf of State of Ohio, Assistant Prosecutor Paul Lilly and Betty Burley, victim assistant Ms. Sarah Reynolds. The court understands there's been a plea reached in this case, and the plea sheet has been handed to the court. The court first takes note. At the top, case number says 20 CR. I think it should be 20.
Oh, sorry.
That's okay. It should be 2024 CR 100. The court received a motion filed by the Sandusky Register to take photographs of these proceedings today, and the court granted that request. And the entry is being filed, or it's been filed in the last few minutes. But the court understands there's been plea reached in this case. Is that correct, counsel?
Yes, Your Honor.
State will how to plea.
Thank you, Your Honor. I'm confident. Your Honor, I paused it on, Mr. Lawrence, you recognize this to be the hearing that we discussed previously that occurred on September 15th of 2025.
Yes.
Your Honor, I don't know, I'm not sure if there's an ability for me to expand it so it can be seen better. Do you have any idea? Okay. I guess the conversation is more important than
Could we turn the volume up a little bit if you can?
I will certainly try. That the defendant has been made aware of all of his rights pursuant to Criminal Rule 11 as a result of my conversations with his counsel, Attorney McGuckie, and as a result of his knowing all of his rights, he's withdrawing his formally entered pleas of not guilty, entering a plea of guilty to counts 2 and 3 of the indictment, each of which are as charged, each being felonies of the 3rd degree, and each being in violation of 2919.25A and D4 felonies of the 3rd degree. In exchange for his pleading guilty to those 2 counts, the state is dismissing counts 1, 4, 5, and 6. As to the counts to which he's under pleas of guilty, he understands the possible penalties would include a period of incarceration on each of 9, 12, 18, 24, 30, or 36 months. They involve 2 separate individuals, as a result of which the sentencing on these could be consecutive. So he is facing a potential prison sentence of 72 months on the 2 counts and a fine of up to $20,000, neither of which are mandatory. He is subject to post-release control for a period of up to 3 years, but not less than 1 year. A request has been made for a pre-sentence investigation report, and the indication on the plea sheet is that the parties will argue at the time of sentencing. I'm sure that the defendant has been made aware that even if Attorney McGuckie and I were to reach consensus on a recommendation to the court at the time of sentencing, the court will independently determine the appropriate sentence, and our recommendation is not binding upon the court. And Your Honor, I believe that is a summary of the plea agreement here tonight.
Thank you, counsel.
Thank you, Your Honor. I've had an opportunity to go over this agreement with my client. I feel like he fully understands the agreement and is ready to move forward.
Thank you. Mr. Boers, that microphone in front of you records. The recorder over here, she has to pick up all these proceedings. Anytime I ask you a question, I need you to answer out loud. I need you to speak loud enough and clear enough that we can hear your answers. I'm going to ask you some questions. They're not designed to trick you or confuse you. They're designed so you understand the ramifications of your plea, and this court can determine if that plea is knowingly, voluntarily, and intelligently given. Now, if during these proceedings you don't understand my questions or you're confused, get your attorney's attention or mine so we can make sure you understand what's happening. There's not a problem if you are. There is a problem if you are and you don't let us know. You have to let us know. Do you understand that?
Yes, Your Honor.
And counsel, pull the mic closer for him, would you please? Thank you. Now, we're going to begin by you stating your full name and spelling just your last name. Go ahead, sir.
Robert Martin Boris, last name B-O-R-E-S.
Date of birth?
2/1890.
You read, write, speak, and understand the English language.
Yes.
What state were you born in?
Ohio.
If you're not a citizen of the United States, conviction of the offense which you're pleading guilty to could have the consequences of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to laws of the United States. You must understand by being found guilty of these offenses, you're under a legal disability on the state of Ohio level as well as the felony level. That disability is you're not allowed to own or possess a firearm or ammunition. If you're ever found in possession of those items, you could be prosecuted both by federal authorities and the state of Ohio and subject to many years in prison in their systems. The state of Ohio, that disability applies unless you've been relieved of it pursuant to law. Are you presently under the influence of drugs, alcohol, prescription medication?
No, Your Honor.
To your knowledge, has a doctor or court ever determined that you are mentally incompetent?
No, Your Honor.
You were served with your indictment in the past. Do you have any questions about that?
No, Your Honor.
You heard the plea agreement here today. Any questions about that?
No.
Are you in agreement with it?
Yes, Your Honor.
Do you understand the nature of the charges you're pleading guilty to?
Yes, Your Honor.
Do you understand if there's any pending motions that are disposed of pursuant to this plea?
Say that again,
Yeah,
please.
let me help you. Sometimes an attorney will file a motion to suppress to keep evidence out of trial, or a motion limiting to keep testimony out of trial. Since you're pleading guilty to the offense, we're not having a trial, those type of motions are disposed of. The court don't have to rule on them, and they're gone because you're pleading guilty. Do you understand that?
Yes, I
You
understand.
need to talk to your counsel about that.
No, Your Honor.
Does that change your mind about the plea?
No, Your
Do you understand that if there's any court costs or fines imposed and you're not making payments on them, the court can have you do community service to pay those obligations?
Yes, Your Honor.
Are you satisfied with your attorney's representation?
Yes, Your Honor.
And do you understand that at the time of sentencing, you, your counsel, the state, the victims, the probation are all going to make a recommendation as to what type of sentence you should get? The court will consider that, but it's not required to go along with it. Even if everybody agrees to the same sentence, that does not mean the court has to give that sentence. The court has to hand down a sentence it believes is just under the law. Do you understand that?
Yes, Your Honor.
Do you realize that the court found you guilty here today or could sentence you immediately today?
No, I didn't understand that.
Okay, not a problem. Your counsel's asked for a pre-sentence report investigation, and I'm going to grant that. So we're not going to be sentencing you today until I get that report. But I have to advise you that I could sentence you today. Do you understand that?
Yes, I understand.
Does that change your mind about the plea?
No, Your Honor.
Okay. Do you realize that a guilty plea is a complete admission of guilt to the offense in which you're under that plea?
Yes, Your Honor.
State, the victim's in agreement with this plea?
Yes, Your Honor. And Ms. Reynolds is here from my office who will explain anything further regarding that, or if we proceed with any other matters on behalf of the victim, she's here to speak on their behalf or have them speak to the court.
And they are here present, so they have notice and they understand the plea. Are they in agreement with this plea?
Yes.
Okay. You understand that the victims have a right to submit to this court a victim's impact statement, which addresses the effects of the crime, the damages they suffered, the type of penalties they'd like to see imposed, things of that nature. Then they have a right to come to your sentencing hearing and make comments to you and to the court regarding this case. Do you understand the victim's rights?
Yes, Your Honor.
You're pleading guilty to 2 felonies of the 3rd degree. They each carry a possible prison term of 9, 12, 18, 24, 30, or 36 months and a fine of up to $10,000. So in effect, you're looking at 6 years in prison and $20,000 in fines. Do you understand that?
Yes, Your Honor.
None of that's mandatory, so the court's not required to send you to prison or impose a fine, but it could. Do you understand that?
Yes, Your Honor.
You're asking for that pre-sentence report investigation. The court will grant that request. When we come back here, the court has a couple of options. One is community sanctions. That's like probation. The other is incarceration. That's prison. Let's talk about community sanctions first. You could be on that for a period of up to 5 years. The court could impose various rehabilitation conditions, getting a job, going to counseling, doing community service, things of that nature. The court can have you pay a supervision fee up to $50 every month that you're on. The court could also place you in a treatment center, a residential sanction such as a community-based correctional facility, or a non-residential sanction like house arrest with electronic monitoring. If you violate the terms of your community sanctions, the court could increase the term up to the maximum allowed by law, which is 5 years. The court could have more restrictive conditions, or the court could revoke your community sanctions and send you to prison. Additionally, if you leave the state of Ohio without permission of the court or the probation department, the court could revoke your community sanctions and send you to prison. That's on that side. The other side is incarceration. If the court decides to send you to prison, anytime you served in custody on this case, that will be credited towards your prison sentence. Once you get to the prison door zone, any portion of the sentence remains, you have to serve it day for day till the sentence is done. When you're done serving the sentence and you come out, you shall be on post-release control for a period of up to 3 years, but not less than 1 year. The parole board, they're going to set certain terms and conditions for you, and if you violate them, although you served your entire prison sentence, they can send you back there. They can send you back there for up to 1/2 the original sentence this court gives you. However, if that violation is based on a new felony, then the court could terminate your post-release control and impose a greater of 1 year, or the time you have remaining on your post-release control, and that has to run consecutive to the new underlying offense. You can appeal this plea hearing and or your sentencing hearing. What you have to understand, though, by pleading guilty, you're admitting to the evidentiary or the factual basis, so you really can't challenge that on appeal. The procedural aspects you can challenge, and if you want to do that, you have to file a document we call a notice of appeal, and you have to file that notice within 30 days of the journalization of the sentencing entry. If you don't file it within those 30 days, you have then waived, forfeited, or given up your right to appeal. Now, Mr. Boris, at this point, I've given you a lot of information. Do you have questions on any of it?
No, I understand.
Understood it all?
Yes.
Okay. I'm sure your counsel has gone over your constitutional rights. He's practiced in this court for a few years now. He's had a lot of cases. Does a good job representing his clients, really thorough. And I'm sure in his representation of you, he's gone over the constitutional rights that you're giving up by pleading guilty. But in spite of all that, the law says I got to do it with you. I have to make sure you understand them, and I got to make sure you're giving them up. So these are your rights. You have the right to go to trial by jury with 12 jurors in this case. Do you understand that right?
Yes, Your Honor.
You want to give up that right?
Yes, Your Honor.
You have the right to have the state prove the case beyond a reasonable doubt as it pertains to the elements of the offense. Do you understand that right?
Yes.
You want to give up that right?
Yes.
You have the right to have that verdict be unanimous. All 12 jurors have to agree on the verdict. Do you understand that right?
Yes.
You want to give up that right?
Yes.
You have the right to cross-examine and confront the state's witnesses at trial. Do you understand that right?
Yes.
You want to give up that right?
Yes.
You have the right to subpoena powers of the court that witnesses come in here and testify on your behalf as it pertains to this case. Do you understand that right?
Yes.
You want to give up that right?
Yes.
You have the right to trial and not to testify. And nobody can force you to take that stand. And if you said, look, I don't want to testify, the state of Ohio cannot comment to the jury about the fact you didn't testify. They can't get up there and say, Mr. Boris is hiding something or he must be guilty because he didn't testify. Not allowed to do that at all. And I'll tell the jury they can't hold it against you that you didn't testify because you have that right. Do you understand that right?
Yes.
You want to give up that right?
Yes.
Do you have any questions about the rights you've given up?
No.
About the possible sentences?
No.
About this plea agreement?
No.
Is there anything about these court proceedings you do not understand?
No.
Has there anything stated off the record outside the courtroom about this plea agreement you think this judge should know about?
No.
Did anyone offer you, promise you, or guarantee you anything in exchange for this plea?
No.
Did anyone force you, coerce you, threaten you, or place you under duress in entering this plea?
No.
There's a forfeiture of property here. You understand you have a legal right to own and possess property that's not contraband. And when the government takes it from you by a police department, and they allege it is contraband, then you have other legal rights under the forfeiture laws. Notice, hearing, proportionality, standard of proof, things of that nature. When you make forfeiture part of the plea agreement, you can not only give up your legal right to own and possess that property, but any legal rights under the forfeiture laws. Do you understand that?
Yes.
If you're accountable to any other court or agency by pleading guilty here today, that court and that agency, they could impose their sanction or penalty. Do you know what I mean by that?
Yes.
Okay, you hesitated a little bit. Did you understand that or not?
Yes, yeah, I was just thinking of what you were saying, and yeah, I
Okay.
understand.
Okay. There'll be no waiver of sentencing, Judge. I'll be sentencing you. On page 4 of 6, counsel, it says, if recommended sentence requires imposition of consecutive sentences, I agree to imposition, waive statutory review. I thought the parties were arguing there's not a recommendation of a sentence.
That was not applicable because there's no limit to
Right.
Okay, that's fine.
I mean, that's generally,
Yeah.
you know, so I'm going to put N/A there. All right, Mr. Boers, one last time before I accept your plea. Do you have any questions, court at all, sir?
No, Your Honor.
Going back to counts 2 and 3, domestic violence, both felonies of the 3rd degree, both in violation of 2919.25 AD4 with 2 separate victims. How do you plead to those counts?
Guilty.
And you're pleading guilty to them because you are guilty, correct?
Yes.
This court finds that this day in open court, the defendant was advised of all his constitutional rights. He made a knowing, intelligent, voluntary waiver of those rights pursuant to criminal 11. The plea is accepted. The order will be filed. The court finds him guilty of each offense in which he's entered his guilty plea. This court will continue his bond, set the matter for sentencing. Bailiff? Okay. December 11th. You available December 11th? You can use that Kleenex there if you want. December 11th. December 11th, 2025, 1:30 p.m. will be your sentencing. When you leave here today, you need to go over to probation immediately and check in. You do know where that is at, right?
Yes.
Take a copy of your plea sheet over there. They have some material for you to fill out for your pre-sentence report investigation. We call that a PSI. Okay, my bailiff's going to email them, so they're expecting you to show up over there. Go over there immediately, then make sure you comply with all your bond conditions. If you don't know what they are, you should, but if you don't, that's the time to ask. Make sure you don't get involved in any other criminal activity and you show up at all your court dates. Now, should you fail to do any one of the things I've just now mentioned, you realize the court can revoke your bond, take you into custody, and consider that non-compliance for purposes of sentencing. Do you understand all that?
Yes.
Do you have any questions, sir?
No, Your Honor.
Counsel, comments?
Your Honor, if I may.
Go ahead.
Briefly, I'd like to discuss the
Yeah, I've stopped it at, I'm trying to figure out the best way for the record. It's at 2:40.23 p.m. I've stopped it, which is the conclusion of the plea hearing portion. The remainder would be the addressing the issue of the bond, which I don't think is relevant for these proceedings here today, Your Honor. Mr. Boers, that was in fact your plea hearing, was it not?
Yes.
Now, Mr. Boers, in the motion to vacate your plea, you also indicate that you, through your counsel, that you deny ever using a prod stick on any of his children. Remember, or do you recall that being included in the motion to withdraw your plea?
Yes.
Do you recall being interviewed by a detective at the Erie County Sheriff's Office back in March of 2024 when this incident first came to the attention of law enforcement?
Yeah, briefly.
That would have been then Detective Daniel Orzak. Do you recall that conversation you had with him?
But I don't recall the whole thing, no.
Okay. Did Attorney Magooky's office provide you with copies of information they had gathered from the state of Ohio through what we call the discovery process?
I'm sorry, say that.
Yes. When I use that discovery process, do you understand what I mean by that?
No.
When the state of Ohio, my office, shares information with your attorney, did your attorney then share information with you that he had gotten from my office?
Yes.
And I trust that somebody from the office of Attorney Magooky would have shared with you or allowed you to watch the interview that you had had with Detective Orzak.
Well, I shared some of it.
Okay. Here, I've marked as State's Exhibit 4 the interview that the defendant had with Detective Orzak. I'd like to play it for him at this time.
Go ahead.
But before I... But Your Honor, before I do that, I'm sorry, Detective Gladys, can you pull back for me? Yeah, thanks. I'm going to mark this as Exhibit 5. Any piece of particular one, doesn't matter. Mr. Boers, just so we all understand the language and what we're talking about, I'm going to show you an item that I have marked as State's Exhibit 5. Do you recognize this item?
Yes.
What would you call this?
Cattle prod.
So when you indicated in the motion to withdraw your plea that you never used a prod on any of your children, this would have been the device to which you were referring, correct?
Yes.
This is the item that was at your home that was the subject of the disclosure to law enforcement about your, we'll call it disciplinary measures, correct?
Yes.
Now, I'm going to go back, if I may, to State's Exhibit 4.
May.
And again, Your Honor, do you mind if I be seated on it?
May.
Dan DeRose from 19 News. As we wait for the interview to be pulled up here, just reviewing what's going on here. You've got Robert Boers, who is trying to withdraw his plea, but you saw the plea hearing replayed in court, where he admitted that no one had made him any promises. No one had, promised him that he would be able to see his kids. But now he's going back on that, saying that that was part of the promise he was made by his own attorney at the time.
Are you able to see the date stamp? Oh, wait, never mind. All right.
I got all that. Let's see that quarter there. This is all my children? Yeah. So, just before we talk, you're obviously in custody, so,
Mr. Boris, I paused the video at 50 seconds. I'm going to ask you if the individual that's depicted in there, the person that's in handcuffs, is that you?
Yes.
And the person with his back to us, would that be Detective Warzek, with whom you spoke on March 14th of 2024 in regards to this matter? Are you?
I'm not sure, I can't see his face and.
Okay, thank you, that's fine. But that is you in the conversation there, correct?
Yes.
Thank you.
I have to give you your Miranda rights, okay? You've obviously heard of those, okay? You have the right to remain silent. Anything you say may be used against you. You have the right to a lawyer. If you can't afford a lawyer, we'll provide for free, and you can stop talking at any time you understand. Are you willing to talk to me? I just need you to sign, print your name, date, and time, and then I'll sign as a witness, okay? But you can stand up or whatever you need to do. And just print your name, yep.
Were you the guy waiting on me yesterday?
No, I wasn't waiting on you. What's that?
I'm usually home by what time?
5:30.
Yeah, I'm usually home by 5:30, but I was pulling containers and stuff.
Oh, were you
yesterday.
working? Yeah.
And I had to take this guy to Sandusky to pick up his car, and I didn't punch out till 6:20.
Of course. That's all right. This time, just put
9:30.
9:09. Yeah, that's good. Okay, there's that. No, sorry. Okay. So, obviously, I already talked to your wife and your children, okay? We went out there, we got a complaint, obviously, from Children's Services. This is just really just to see what your side is. I give everybody an opportunity to be honest with me, okay? A long way with me. And honesty goes a long way with the court, okay?
Yeah.
So,
Completely honest with you.
yeah, so just explain, okay, you obviously know the complaint that was made against you, right? Okay, and that was that you were using the cow prong or pig prong for your children, right?
Right.
Okay, so go ahead and explain why you were doing that.
Okay. Let me start from the beginning.
Yep.
I wasn't doing it to abuse them
Okay.
or hurt them in any such way.
Yeah.
They're my children. I love them.
Yeah.
You know, I didn't sit there and shock the hell out of them.
Yeah.
You know, I pushed the button. When you push the button, that's when it really shocks.
Yeah.
Then I would let it go.
Right.
I wouldn't touch them with it.
Yeah.
And then I would tap them on their butt with it.
Yeah.
You know, I wasn't sticking them anywhere else.
Yeah.
And it was only my son. I think I got my son twice.
Yeah.
And I did my daughter once.
Yeah.
Other than that, I was using it as a scare tactic.
Right.
Just to try and get them to listen.
Right.
I understand that it probably wasn't the right thing to do.
Yeah, and that's you. I mean, you and me can agree on that, right?
Yes.
Yeah.
Yeah.
And I think we can all agree on that. Anybody that can see the situation, okay?
No, I love them kids, man.
Yeah, I get that, and I know parenting's hard. I have 3 kids of my own, right? And they don't listen.
Right.
They're all the same. You know what I mean? The more you talk to other parents, the more they're saying. Okay. I think why you're here, obviously, is what transpired. You know what I mean? Like, that's why we're here, is because you use that. You know, obviously you're allowed to discipline your kid, just not with a cow prong.
Yeah, but
Okay.
I know, I'm not trying to
Yeah.
say it was right.
Yeah.
But I feel like it was less of a punishment than
Yeah.
getting a belt.
Right.
'Cause I mean, I don't know if you ever used one of those things. I know how they work.
Yeah.
If you don't hold that button onto them, it's not gonna give them a hard shot.
Yeah. But it still hurts a 40-pound kid, right?
Yeah,
Can
yeah.
we agree on that?
It'll, give,
Yeah.
it'll feel like maybe like a horse fly or a fly bites you.
Yeah.
That's what it'll feel.
Yeah. But it still,
Yeah.
it still hurts.
Yeah.
Okay.
I just
and I could tell.
Here, I've stopped the video at 4 minutes and 59 seconds. So, Mr. Boers, in that interview that you had with Detective Orzak, I'm accurate, am I not, when I say that you told him that touching your children with that cattle prod was like getting bit by a horsefly?
Correct.
So in your motion to withdraw your plea, where you said you never used the cattle prod on the kid, that wasn't true either, was it?
I wouldn't say I would use it on them if it was off. I would say, no, I did not use it on them.
So if
Nah.
it's, so if it's off, touch the end of that for me, if you would, please. Does that feel like a horsefly biting you?
Yeah, it could.
Does it? I'm not saying what it could. I'm
Yeah.
asking right now, by touching the end of that, does that feel like it's a horsefly biting you?
Yeah.
Mr. Boers, have you ever been convicted of a felony offense prior to your plea in this case?
Yes.
What felony offenses have you been convicted of?
It was a fleeing and eluding.
And as a result of that, you went through a plea hearing as well?
Yeah, I must have.
Okay. In fact, that was with Judge Burnett, was it not, back in a 2012 case?
Yes.
And are there any other felony convictions that you've had in the last 10 years?
I don't think so.
Isn't it true, Mr. Boers, the only reason that we're here is because as a result of your bond violation, you are worried that you will now suffer a greater consequence for your behavior in this case because Judge Burnett told you that could happen, correct?
No.
So after you were denied the contact with your children that you wanted, that you claim you were promised, and prior to your new offense of OVI that you were charged in October, not once did you ask that your plea be withdrawn, correct?
Yeah, that's good.
Why?
I told you, I didn't know I could do that.
You didn't realize that you could file a motion to withdraw a plea because the alleged promises that you said were made were not followed through with?
No, because I asked Jonathan to do a lot of things for me and he didn't do anything.
What did you ask him to do that he
I
did not?
asked him to see my kids as soon as this stuff happened. And he waited almost a year before he filed anything.
And asking that would be through a request of Judge Burnett to grant you that permission, correct?
Objection, Your Honor.
Basis?
You did not have the case at that point in time.
Sustain.
Oh,
doesn't-
I
That's
apologize.
sustain.
Thank you. And that would require you asking the judge that was assigned the case at the time you were charged to modify your bond, correct?
That would be correct if I was able to talk to anybody. The only person I was allowed to talk to was Jonathan.
And it's your testimony that you requested that he file with the court, whether it was Judge McGookie, to whom the case was previously assigned, or Judge Burnett, that your bond be modified, correct? To allow contact with the children.
I didn't catch the beginning.
Oh, I'm sorry. Are you telling us that from the time of Attorney McGookie's representation of you, that you asked him to file a request with either Judge McGookie and or Judge Burnett to see your children?
Yes, every time I talk to him.
And is it your testimony that he did not do that until he argued for that on your behalf on the day of your plea?
I believe he filed in February of 25.
Okay. So prior to the plea, he did in fact follow through requesting that you have contact with the children, correct?
Yes, after 11 months.
And that request was denied, correct?
Correct.
Your request in September of 2025, at the time of your plea hearing, that request was denied the next day, correct?
Correct.
But it was not until after you had a new criminal charge, did you attempt to withdraw your plea? Correct?
Yeah, I don't see why this pertains to that. It's got nothing to do with this.
Well, Mr. Boris, how about this? The fear of a greater sanction makes you want to start over again with a plea negotiation. Could that possibly be the reason that we're here?
No.
You mentioned that you're dissatisfied with the services of Attorney Magucki. In what regard, other than what you've already said, are you dissatisfied with what he did on your behalf at the time of the plea?
What am I dissatisfied with?
Yeah.
He would never answer his phone calls. I think I had 3 meetings with him in the whole year and a half he was my attorney.
Okay.
Every time I tried to explain to him, he acted like he didn't care what I had to say.
When you told Judge Vanette,
Wait a second. I'm done, sir. Is there any
oh,
more?
I'm sorry.
There's probably a bunch more I just can't think of right now.
Okay.
Oh, I'm
Next
sorry,
question.
thank you. So when you said to Judge Vanette during your plea that you were satisfied with the services of your attorney, you were misrepresenting that to Judge Vanette.
Yes, because he guaranteed, he said he would not take the deal on my behalf if I didn't get to see my kids.
That's not responsive. Ask the question
Yeah,
again and
okay.
listen to the question.
When you advised Judge Vanette on September 15th of 2025 during your plea hearing that you were satisfied with the services of your attorney, was that a misrepresentation to the judge?
Yes.
Why did you make that misrepresentation?
Because Jonathan McDuffie told me, he said specifically he would not take the agreement on my behalf if it was not a guarantee I get to see my children.
And did he explain to you how he could make that guarantee with it being a decision that the court would have to make?
No, he didn't explain it.
But you understood by September 16th or a few days thereafter that you were not going to be able to see your children.
That's correct.
Thank you, Your Honor. At this time, I don't have anything further. Mr. Boris.
Redirect.
Thank you, Your Honor. May I sit here?
Stand.
Okay, thank you.
You're saying a document or something or a video all right, but you're not, so
All right, that's fine.
state take it down.
Mr. Boris, I want to start with the plea agreement hearing that you attended on September 15th. You had an opportunity to look at that today, is that correct?
Yes.
Have you previously had an opportunity to look at that video at my office?
Yes.
When did you do so?
Tuesday.
Okay. Did you discuss, I'm not interested in what you discussed, but did you discuss what it was that you did not understand on that video, if in fact there was anything you did not understand?
Your Honor,
Yes.
Your Honor, if Attorney English is asking him about conversations that the two of them had with one another,
No, I think he's heard it right now that he's not getting into the actual discussion at this point. He just asked if there was something he didn't understand. If the answer comes out and another question comes along those lines, then maybe, but not right now.
okay, thank you.
You're welcome. Continue, counsel.
Thank you, Your Honor. Was there anything about the manner in which Judge Burnett spoke during the hearing that was problematic for you?
Yes.
And what do you mean by the word, I'm using the word problematic? Was there something that caused you any concern about the manner in which the judge explained anything that he explained that you looked at today?
Yes.
What was that?
I no disrespect to you, Your Honor, that, I mean, he talked extremely fast. And, but even still, I got to watch that video another 5 times to actually be able to try and comprehend what was really going on.
Had you ever, I understand that Ms. Lilly asked you if you'd ever had a prior sentencing with this judge. The answer was yes. Is that correct?
Yes.
Was that the 2012 case?
Yes.
Okay. Did you have a similar problem at that point? Or do you recall it?
I don't recall.
Okay. Prior to coming into the courtroom and the judge going through this form that we have identified, had you seen the form itself?
What form are you talking
Well, there is an exhibit. I believe it is, Paulette, correct me if I'm wrong, it is Exhibit 1. Is that correct? Your Exhibit 1?
The police sheet?
Yes, the police sheet.
The exhibit should remain up here.
Yeah.
There, exhibit 1.
Yes.
Or you mark 1.
So, Mr. Boros, I'm referring to that document marked as Exhibit 1 with a red sticker.
about?
Can you tell me whether you saw that document prior to coming in front of the judge on September 15th of 2025?
Yeah, yes, the day of, very briefly.
Okay? And where were you at the time when you saw the form? Were you here in the courtroom, or were you in some other location?
There was a room across the hall from here.
Okay? And who showed it to you?
Jonathan McGuty.
Did you have an opportunity to read it?
No.
Did you have an opportunity to have it explained to you by your lawyer?
No.
How long were you in that little room across the hall, which we'll call the smaller courtroom?
I mean, I would say 5 minutes or less.
Okay? So when you came in front of the judge, did you have any comprehension of what would happen in the plea hearing itself?
The only comprehension I had was I was pleading guilty to 2 felony charges in regards that I was going to be able to see my children.
Okay. Now, let's deal with the promise that you say was made by Mr. McGucki, your former attorney, to you. On August 11th of 2025, were you present here at the Erie County Court of Common Pleas for what is called a pretrial conference?
Yes, I've never missed a court.
Okay. And was that the first time that you had an awareness that Judge Bennett was handling your case rather than Judge McGucki?
Objection
Basis?
beyond scope.
Overruled. I'll allow it. You can answer.
What's the question?
Okay. Initially, let me back up even further. At the time when you were indicted, you know what that means?
Yes.
You were charged, correct? The case was assigned to a judge. Which judge had your case?
Judge McGuty.
Okay. Did you ever go in front of Judge McGucki at any time during this process?
I believe the first time I came to court.
Okay, that was called the arraignment. Is that correct? Do you know what an arraignment is?
Objection.
Overruled.
I don't know the explanation. No.
Okay, so you went in front of her on one occasion. Is that correct?
From what I remember, yes.
Okay. And on August 11th of 2025, now I've come more than a year later, when Judge Bennett had a pretrial conference on August 11th, did you appear in front of the judge himself? In other words, you sat at this trial table and there was discussion about your case.
I don't recall.
Okay. So when you came here on September 25th of 2025, was that, excuse me, September 15th of 2025, was that the first time since 2012 that you had seen Judge Bennett?
Yes.
Did you remember him?
Yes.
Okay. In fact, did you have a conversation with your lawyer about whether Judge Bennett could serve in this case in light of what had previously occurred?
Yes, I did.
Okay. So when you came here, you had a 5-minute conversation with your attorney in the other room about this plea that you were going to enter, correct?
Yes.
You saw this document, but you did not, Exhibit 1 that you have in front of you, that you folded over, but you did not read it. Is that correct?
Yes.
Were there a lot of words in the document that you didn't understand?
Your Honor, I'm going to object to.
Overruled. No allow it.
Yes.
Okay. Did you have an opportunity to ask Jonathan Mabuki what those words meant?
No.
Okay. So when you came in, the judge began to talk, and he was decent to you. Would that be correct?
Yes.
He wasn't hostile in any manner. Okay. But he spoke, you said he spoke very fast. Was that part of your inability to understand what was going on?
Probably yes.
Well,
I'm sorry, I could not hear the answer. May I
He said probably yes.
Thank you.
you said basically yes to everything the judge asked you. Why did you do that?
I mean, what it led down to, I knew the right or wrong answers to the questions from what I was briefly explained what I needed to do in order for me to see my children.
And what was that? What did you need to do to
Agree.
see your kids? You needed to agree.
Agree?
Okay, so that's what you did.
Yes.
One question the judge asked you, is there anything that the judge should know about in regard to your case? Did you say anything about the promise that had been made to you on which you say you were relying in order to plead guilty?
No.
Why did you not say that?
You know, I don't know. I did try and speak, and I was told at one time that I could speak at sentencing. I don't recall everything, to be honest with you.
Okay, now, one of the questions you were asked today is, what did Jonathan Mabuki do or not do that you found to be inappropriate? You follow that question? It wasn't asked exactly that way, but,
Yes.
okay. Now, there's a concept called discovery, which I understand was explained to you, information the prosecutor gave to your attorney, who would thereupon inform you about that information. Is that correct?
Yes.
At some point, did you go to Mr. Mabuki's office to review a large stack of paper that came from somewhere?
Yes.
And how long did you spend reviewing this large stack of paper?
I was trying to review it by myself. I was maybe a half hour to an hour.
Okay. Were you able to read every page of
No.
the paper?
No.
Did you have any explanation that was provided to you by your lawyer at that time about what that paper was?
No.
Do you now know that that was all the discovery that the state of Ohio produced?
Yes.
Okay, and that's because you have looked at it at my office, is that correct?
Correct.
And have you spent much more time than that, at least examining what had been provided?
Yes, sir. You wrote no page by page.
Okay. Now, there was also a video, and the prosecutor asked you if there were several videos that you were sent by Mr. Mabuki so you could look at them at your house. Did that ever happen?
No.
Okay, so,
Objection.
Basis?
I think it was a misstatement of, my understanding of the way the question was framed is that he was suggesting that I, in my questions of Mr. Boris, said something about things being sent to his home.
I'll withdraw
Thank you.
and ask you to go on.
Thank you.
You were asked about videos that you were able to either look at your house or at your attorney's office, correct?
Objection.
Basis?
He was not.
Let me withdraw it again, and I'll ask you, did you ever see that video that you looked at today? Exhibit number 4.
Which one?
You had an interview, a quote interview. There was a detective that you came into a room. Did you see that on the video today?
Yes.
Okay, and when was that in relation to when you were arrested?
I don't understand.
Okay, you got arrested sometime on this case, is that correct?
Right.
Okay, you were taken to jail, is that correct?
Yes.
Okay. When did the detective, whose name you don't remember, is that correct?
I remember.
Okay, what is his name?
His name's Daniel Orsted, something.
And when did he come in and talk with you about this case?
While I was incarcerated, next day or the day after.
Okay. You signed a waiver of your legal rights, what's called a Miranda waiver, is that correct?
Yeah.
You knew you had the right to remain silent. Anything you say can and would be used against you. You had a right to stop talking at any point. You had a right, is that correct?
Yes.
Did you understand that?
Yes.
Okay, you wanted to talk to the detective about what the facts were. Is that correct?
Yes.
Okay. And then you had a discussion. It's much more lengthy than what was shown in the courtroom today. Is that correct?
Yes.
Okay. And during that time, you discussed what your view was of what you had done or not done. Is that correct?
Yes.
I don't want to talk about that. I'm asking you, did you have an opportunity to look at that same video at Mr. Maguki's office?
Very briefly, he did come in at the end and he was kind of flipping through that video,
Flipping through the video.
like fast forwarding.
Okay. Did you have an opportunity to look at the whole video?
No, sir.
Just parts? Did you have an opportunity to speak with Mr. Maguki about any significance the video may have in your case?
No.
Okay. Did you ever subsequently receive the video so that you could look at it yourself at home?
No.
Were you ever given an opportunity to review that video at any other time other than the one time when you went to Mr. Maguki's office?
No.
Did you look at the video before you entered a plea of guilty in this case?
Yes.
At the time when Mr. Maguki showed it to you initially?
Right. Yes.
But you were not in the room when the video was initially examined? Is that accurate or not?
No, I was in the room. He turned it on and he was flipping, like I said, he was fast forwarding to parts and pieces he was pointing out. But no, I didn't watch the whole video.
Okay. Did you understand on August 11th of 2025, when you came for a pretrial conference, that an offer, what's called a plea offer, had been made by the state of Ohio through the prosecutor?
There was a lot of those the past year and a half.
Okay? So you don't remember whether one was made or not?
No, I don't remember.
Did you understand that a trial was scheduled for September 23rd of 2025 if you did not enter into a plea agreement?
Yes.
Did that play any role in you deciding to enter a plea in the case?
Yes.
Did you want to go to trial, or did you want to avoid going to trial?
It was kind of both, if I could explain.
Yes, please.
I wanted to go to trial to get everything known, but I didn't want my children to be in front of all this. After all they've been through, this would be terrifying for them.
Okay.
Dan DeRose with 19 News. As we have a little bit of a break here, a little bit of a pause, for some of you watching on our digital properties at 3 o'clock, you're going to see this switch over to our Channel 19 News at 3. If you'd like to continue watching the hearing, you will have to go to cleveland19.com. Go to our YouTube channel, go to the Cleveland 19 YouTube channel to continue watching this. If you want to continue watching it, all of a sudden you see our 3 o'clock news start, go to our YouTube channel and go to YouTube and type in Cleveland 19 and you'll be able to continue watching.
What about that? Yes. Were you able to speak with him?
No, I didn't.
On October 6th of 2025, Judge Bennett issued an order for your arrest because you had allegedly violated a bond condition by having another criminal charge against you. Are you aware of that?
Yes.
Did you speak with Mr. McGoopy that day about this matter?
Yes, it was the first Monday of October is when I spoke to Jonathan.
Okay. Were you able to speak to him about what had transpired for which you were not now seeing your kids and the agreement that you had made to plead was based?
No.
Okay. And why not?
He told me I had to go turn myself in. It seemed like all he was worried about.
Okay. You hired a separate lawyer to represent you, is that correct?
Yes.
And was that me?
Yes.
And was I hired at that point to address this case as well as the second case you picked up?
Yes.
And you filed on December 11th of December 10th of 2025, a motion to withdraw your plea. Is that correct?
Yes.
Have you looked carefully at that motion?
Probably not the best I should.
But you read it?
Yes.
Certainly. You helped me prepare it, is that correct?
Yes.
You have subsequently prepared a supplemental memorandum in support of your motion, is that correct?
Yes.
And have you read that?
Yes.
Is that document and the allegations that are made in that document true and complete to the best of your understanding?
Yes.
Is there anything more that you can tell us about why you want to withdraw your plea and actually go to trial, which would involve your kids potentially testifying?
Yes.
Why is that?
Well, I don't know who brought in the so-called victims that were over here the past couple times I was here. I don't know how they're victims in this case. The actual victims are supposedly my children. And they, as far as I know, they haven't spoken to this court not one time. I mean, from my knowledge, what I was explained that the victims have rights to talk and rights to how they want things to go. And all I hear is hearsay from a victim's advocate is what people are saying. It just sounds like hearsay to me.
Okay. But you definitely want to go to trial at this point.
Yes, sir.
And does that have anything to do with you just now feeling, well, maybe something bad's gonna happen to you as a result of the sentence, so you wanna withdraw your plea? Or is it because you have a different motivation?
I have a different motivation. I mean, it
What
could be
is that
bad either way.
motivation?
Motivation is to get the truth out. I mean, you're posting all this stuff all over the news, all over social medias. There's no truth going on with it.
Okay. I have no further questions, thank you.
Recross.
Thank you. Just a few questions, John. Mr. Boers, are you still in possession of State's Exhibit 1, the police chief?
Yes.
Can you identify, you testified with your counsel's questions that there were portions of that document you did not understand.
Yeah, I mean, I still haven't even fully read it over.
Okay, well, I'm going to ask you to tell us, do you understand what the word guilty means?
Yes.
Okay, and that's circled on page 1, right?
Yes.
So you knew when looking at this plea sheet on September 15th, that, and based upon the conversation that you had with Judge Burnett, that you were pleading guilty to 2 crimes of domestic violence, correct?
Yes.
You knew from the indictment, which you said to Judge Burnett, you understood, that those 2 counts involved the 2 children that you used the cattle prod on based upon your interview with Detective Orzak, correct?
No, that's not correct.
It was not correct?
No, from the paper I seen, it said Olivia Roberts and my daughter. That's not correct.
Okay. And isn't it true in the interview with Detective Orzak, and I'll be happy if you would like to play the remainder of that interview, you indicate that there were the 2, you said, I used it on my son twice, I think, and my daughter once, but I never did it to Olivia. Isn't that what you told Detective Orzak?
That's correct.
So the counts to which you entered a plea of guilty were involving your son and your daughter, and not the count involving Olivia, correct?
I'm sorry, say that again.
Yeah, you pled guilty to the counts that involved your son and your daughter, and I, the state of Ohio, and me as their representative, dismissed the remaining counts that would have included the allegations regarding Olivia, correct?
It's not specifying any names or anything.
Okay. So let's move on and tell me, what else about this plea sheet do you not understand, or did you not understand as far as the words that were used in it?
I'm not sure what else to say, to be honest with you.
Okay. And we heard you in your dialogue, your conversation with Judge Burnett, where on more than one occasion, he asked you, do you understand or do you have any questions, correct?
Yes.
And not once did you say, Judge, there's part of this paperwork here that I don't get. You never said that.
There's a reason behind that.
You were withholding information from the judge, is that what you're telling us?
No,
You were lying to the judge, is that what you're telling us?
no.
You were misrepresenting something to the judge?
I was agreeing in a promise of me to guarantee to see my children.
Mr. Boers, how logical is it to believe that now that you've pled guilty on September 15th of 2025 to being involved in the commission of offenses of violence of a 3rd-degree felony level against 2 children, that the likelihood that the judge is then going to say, you know, now, Mr. Boers, now you've admitted you did these horrible things to your children, let's just reunite you so you can move on and have a great time with them. What's the logic behind that belief?
I totally agree with you.
So-
I'm glad you said that, because Jonathan, he told me to take your deal of taking 3 years in prison, and I would get to see my children. And I said, Jonathan, that makes no sense to me.
So you believe that pleading to, as opposed to accepting a previously provided offer of a 3-year prison sentence, that you had a better shot of seeing your children pleading guilty and thus arguing for what could be a 6-year prison sentence?
Yes.
Again, why would the court grant you the right to see your children immediately after you admitted causing them harm.
Objection, Your Honor.
Basis.
That's pure speculation. She's asking him to speculate about what you would do.
That's sustained. Rephrase it.
Okay, thank you. In that discovery that we've talked about, you had the opportunity, am I correct, to look at the interviews that were done with your children, correct? Prior to you being charged,
Prior to being charged.
yeah, your children were interviewed and provided information in the law enforcement investigation about things that had happened to them, correct?
No, I didn't see it prior to being charged.
So, no, I mean, I'm sorry. The interviews, I apologize, the interviews happened before you were charged, but you got to see those interviews after you had been charged.
I seen an interview from when he was in my house,
I'm sorry, when who was in your house, please?
children's services and all the cops and detectives.
But as part of that information that was shared with you by Attorney McGookie's office, you were able to watch the interviews of your children wherein they made disclosures about the cattle prod.
Objection.
Basis.
I don't believe that's accurate at all, Your Honor. That's not what has been demonstrated here today. Is this a video recording? Is that what she's suggesting?
Lay foundation.
Mr. Boers, are you aware that the children who are the subject of this case, the victims, were interviewed regarding what they alleged you had done to them?
Yes.
And you had the opportunity to watch those interviews?
No.
Did somebody describe for you what was included in those interviews?
No.
What was said? So nobody ever told you what the allegations against you were?
Did you say it in a different way?
Yes. Did anybody explain to you what had been reported to law enforcement?
Yes.
And did you get to see the police reports that summarized those allegations?
Yes.
So you were aware of what the children were reporting?
Yes.
And you were present during the plea hearing when, after the plea, the discussion was had by representatives about the position of the children or on their behalf, whether or not you should have contact with them. That's what you were complaining about earlier, about other people being here talking on behalf of your children rather than your children themselves.
I'm sorry, I just didn't understand.
Yes. Sure. When you were complaining in your testimony about other people talking about what your children wanted, you were unhappy about that, correct?
Yes.
But they were representing what the belief on their part was about what your children wanted as far as contact with you. I'm sorry if I'll be happy to rephrase my question if I've said it in a confusing manner.
Yes, please.
Okay, thank you. Never mind, I will withdraw the question, Your Honor. Your Honor, at this time, I don't have anything else on Mr. Bates.
All right, I have one question. I want to clarify something. On redirect, your counsel asked you if you recalled seeing myself for a pretrial on August 11th of 2025. Do you recall being in court or seeing the judge? What was your answer to that?
I don't recall.
Don't recall?
As far as I remember, every time I had court with you, I think I did always come in the courtroom.
Okay. Only questions within the scope of my question. Counsel?
No other questions, Your
Only
Honor.
questions within the scope of my questions.
Nothing else, then.
You may step down, watch your step. Next witness.
Thank you.
You guys need these papers?
Yes, leave them there.
I have no other witnesses, Your Honor.
Okay, very good. Stage, do you have any witnesses?
I do. I have, at this time, I would call Attorney Jonathan McGookie.
Okay, let's call the witness.
Yeah, I know, but she has anything to say about this.
Remain standing and raise your right hand. Turn and look at me. Do you swear to tell the truth, the whole truth, and nothing but the truth as you swear to God?
Yes, Your Honor.
Have a seat, sir. I'm sure you've seen these instructions to witnesses when you've been in court representing clients, but I want to go over them with you as well. Lady behind you is recording these proceedings, so you must verbalize all your answers. Head shakes, yes or no, will not get picked up. Don't answer by saying, because we don't know what that means. Speak loud enough that everybody in the courtroom can hear your answers. If you hear the word objection, stop talking. I'll let you know whether or not you can finish your answers. You're the answer man. You're going to ask you questions. You give us answers in that regard. You can't ask them questions. You get the answer. However, if you don't, the exception is if you don't understand their question, you certainly could say, do you mean this? Are you referring to that? Could you rephrase? I want you to understand the question before you give us an answer. Two types of questions. One type's a yes or no. The other type's an explaining. A yes/no question would be, is it snowing today? Simple yes or no. An explaining would be, what did you do? Where'd you go? What'd you see? Whenever they ask an explaining question, you explain. When they ask a yes or no, you answer yes or no. Here's the concern. You may get a yes or no question, and you're going to want to explain. You can't. You got to answer yes or no. After you answer yes or no, you can ask the attorney, can I explain? If they say yes, go ahead. If they say no, you must be stuck with the yes or no answer. The other attorney then can get up and decide if they want you to explain. Listen to the entire question before you give us an answer. Seen it many times. The question starts, the witness answers, the question is finished, and now we got the wrong answer. Listen entirely to the question, determine if it's a yes or no, and explain, and give us that type of answer. Do you have any questions, court also?
No, Your Honor.
We're going to begin by stating your full name, spelling your last name for the record. Proceed.
Jonathan McGookie, McGooky.
State inquire.
Thank you, Your Honor. Sir, what is your occupation?
I'm an attorney.
And are you associated with any particular law firm?
Why is that right?
And for how long have you been associated, how long have you been practicing law?
Since 2016.
Is there any particular area of law that you concentrate on in your practice?
I do all criminal defense.
And in the course of that, are there certain protocols that you follow in your representation of individuals who are under indictment for criminal charges?
I don't know what you mean by protocols, but...
Okay, I'll be more specific. Post-indictment, if you are retained by somebody who is charged with a criminal offense,
Yes.
are there occasions where you request information from the state of Ohio relative to the facts and the evidence in support of any alleged crimes?
Yes, I'm familiar with the process of criminal cases. We request discovery, meet with clients, etc.
When you request discovery and you're provided that information from the state of Ohio on a particular case, what do you do with that information as it relates to your client?
So I would review it. Often we meet with clients. Sometimes it'll be phone appointment. Most of the time in person. We give them an opportunity to review everything that's not counsel only. And we go over it with it. Anything that is counsel only, we have to describe it to them. We can't show them to them directly.
And counsel only, just for the sake of the clarity of that, would that be accurate? That's information that you might receive that is prohibited from being disclosed to anybody other than the attorney representing the defendant?
Yes.
Are you former counsel for an individual by the name of Robert Boris?
Yes, I am.
And I'm assuming you were stipulating to the identity of your client?
Yes, we are.
Okay, thank you.
Noted on the record.
Thank
Proceed.
you. Attorney McGooky, do you recall the period of time during which you were legal counsel for Mr. Boers in relation to the case that we're here about today?
I recall in general some of the specifics. I don't have my case file with me, so I'm not going to have no dates or anything like that.
If I were to indicate that he, based on the evidence that we've been talking about, that in roughly March of 2024, that Mr. Boers was charged or arrested for alleged offenses against his children, would that be the approximate time frame where you began representing him?
Yes.
And do you recall roughly when your representation of him ended?
A few months ago. I can't give you the date.
Okay, let me again put things in context. Were you the attorney representing Mr. Boers on September 15th of 2025 when a plea of guilty was entered on the case that was pending that we're here about today?
Yes.
And were you actually in the courtroom with him at the time that he entered that plea of guilty to 2 counts of domestic violence, felonies of the 3rd degree?
Yes.
On that date of September 15th of 2025, and prior to him entering his plea in the courtroom and on the record, would you have had an opportunity to discuss with him, may I approach him?
You may.
Exhibits right there. What I'm handing you is marked as State's Exhibit 1.
I would have had an opportunity, yes.
And do you follow a general procedure when reviewing with any client who's about to go into a courtroom and enter a plea of guilty? Explain to us that process as it relates to your review of that document with your clients.
Objection, Your Honor.
Based-
It's irrelevant.
Overruled. Answer.
So, yes, I do have a general procedure.
Okay, can you explain first then, if you would please, that procedure?
Yes, I don't want to go into particular communications with this client, but in general, there are legal requirements for what I have to go over. And I make sure to comply with those. There's what's called your criminal 11 rights. So you have to go over maximum penalties, maximum potential penalties for each offense. You have to go over what they're pleading to. If there's an agreed sentence with the prosecution, you have to let them know that it's agreed, but the judge does not necessarily have to follow the agreement. And then, like I said, everything in criminal 11, and I don't think it's, for this hearing, I think necessary to go over all those rights.
Your Honor, I'm going to ask that he be permitted, based upon the testimony that he would not be aware was elicited from the defendant through his counsel and in the cross-examination, that he be permitted to describe what he reviewed with Mr. Boers prior to him entering the plea.
That's allowed.
Thank you.
Answer the questions.
So if you would
Let the
have-
record show my objection, Your Honor.
It's noted on the record, overruled.
Thank you.
Proceed.
So with respect to Mr. Boers in particular, and based upon Exhibit 1 that you have before you, what would you have explained to him regarding him entering a plea on that day if that were to occur?
Objection, Your Honor. That is an improper question. The issue is what he did explain, not what he would have explained.
All right.
Rephrase.
Certainly. What did you explain to Mr. Boers relative to him entering the plea in advance of him doing so on September 15th of 2025?
And again, I object.
Note on the record, overruled. Counsel had inquired of his client whether Attorney McGookie had gone over all these things when his examination of the defendant. The defendant had said no, not everything, and things, testimony in that nature. The state's inquiring into that, so that's what you
Your Honor,
testify
I
to.
respectfully-
Don't interrupt the court. I'm not done.
I'm sorry. Please finish.
I will. So, court's going to allow that limited into that and not anything else that pertains to why they're entering the plea outside of the bond issue that's been brought up. Nothing else, okay?
Yes, I
Now
understand.
your comment.
Your Honor, I just respectfully disagree with your characterization of what I asked and what my client answered in respect to that matter.
It's on the record. Proceed.
So your question was my clients with Mr. Boers on September 15th of 2025?
Yes, and if I may, I'll preface my question with, there's been testimony by Mr. Boers that the two of you met in a room across the hall from the
Objection,
court.
Your Honor.
Let her
This is a
finish the
leading-
question. Let her finish the question. You have a habit of interrupting. And not only in this case, in other cases with this court. And I've admonished you before, and I'm not going to do it again. The next time will be other action by this court. Finish your question, then I'll hear your objection. Finish your question, don't answer until I hear your objection.
Thank you, Your Honor. There's been testimony by Mr. Boers that he and you met in the room across the hall from the courtroom that we're in now to review State's Exhibit 1. If you would, please explain what you would have reviewed with Mr. Boers relative to that State's Exhibit 1 in meeting of him on that day.
Now, your objection.
Your Honor, I object. I think that is an improper question. It is, first of all, leading question. Second of all, is mischaracterizing what the evidence was. And thirdly, Mr. McGookie is not entitled to that information.
Well, you led your witness many times on your direct examination, and the court allowed it. And also, leading questions in the evidence rules are designed to protect jurors that don't understand how to weigh the evidence accordingly. They're very relaxed in these type of proceedings. So the court is going to deny that. Additionally, I took meticulous notes about what was said on testimony of your client regarding what he was advised, what he understood, and things of that nature. That's on the record. That's what the state's inquiring. It's overruled. Your objection to my rulings noted on the record, preserved if necessary. Answer the question now.
So, this plea paper generally in this court, and I'm sure that's what happened on this day as well, the plea would have been actually written up that day. We had an outline of an agreement.
When you refer to we, to whom are you referring?
Myself, you, the prosecutor, and me through Mr. Boris. So when you're negotiating a plea, it's the defense attorney, the prosecutor assigned to the case, discuss a resolution. I mean, if you're talking particularly on the date of the 15th, because this has been a long case, there was quite a few different plea offers and resolutions, and we ultimately came to this. And our discussions in the room related to the plea and certain recommendations related to bond after the plea.
Would it be accurate that State's Exhibit 1 would memorialize what you and your client believed was the agreement that had been reached between the defense and the prosecution to resolve this case?
Objection.
Overruled. Proceed and answer.
Yes, I believe we stated on the record this is the agreement that we had.
And that document, State's Exhibit 1, bears your signature. If you need to refer to it, I believe that's probably page 6.
That is my signature, yes.
And your client's signature, which would appear on page 5.
Yes.
As an attorney representing defendants who are entering pleas, what, if anything, do you do to ensure that they understand what's going to be happening and that it is consistent with their desires?
Objection.
Basis.
It's not related to this client.
Related to this client.
Okay.
What did he do in this case with this client?
Then with respect to Mr. Wars, in your review of State's Exhibit 1 with him, prior to him coming into the courtroom, what would you have done to ensure, what did you do to ensure that he knew what he was doing?
So it starts with the entirety of what we do as criminal defense attorneys, understanding what he's charged with, potential penalties, the evidence, everything like that. And then when you're coming to an agreement, you go to the pros and cons of it, related to the evidence. I mean, with regards to the particulars of the case, I really don't think I should get into that, but we definitely did go over everything, every piece of evidence related to this case. Then we discussed, what it meant to do an open sentencing and what a plea to 2F3s means, what a plea hearing is, what a PSI is, what a sentencing hearing is.
And you did that, all of those things you just described with Mr. Boris, the defendant here today, prior to him coming into the courtroom and offering the plea to Judge Bennett.
Yes.
And prior to that, there have been allegations and testimony that you did not share with him all of the information that you had gathered during the course of that discovery process. Is that correct?
I don't know what information about you. No, it's not correct.
Did Mr. Boris, on the day of his plea, September 15th of 2025, indicate to you prior to coming in the courtroom that he was entering a plea to something that he was not guilty of?
Objection.
Basis.
Covered by the attorney-client privilege, so it wasn't waived.
Overruled. Question is, you don't have to describe what it was, but did he?
I think that conversation never came up, whether, it was explaining what it means to plead these. And
There has been an allegation that you advised Mr. Boris that by entering this plea of guilty to the 2 domestic violence charges, that would guarantee him an opportunity to see his children who he had not been permitted to see pursuant to the conditions of a bond?
Your Honor, I object completely. That is not what was said ever.
Overruled. Answer the question.
Did you represent to Mr. Boers that there, or guarantee him that a plea of guilty to these crimes would allow him to see his children?
So,
Yes or no?
if I could expound on the history of it, so there's an understanding, but the answer is to whether or not he was told for sure he would see his kids or that he was getting a recommendation. The answer is no. I
Right.
can
I
explain
just
how we
want-
came to that spot if
Well,
you'd like.
but don't get ahead of my question,
Okay.
please. So is your answer that you never promised or guaranteed Mr. Boers that by pleading guilty on September 15th, he was assured to be able to see his children?
Objection, Your Honor.
Overruled.
So,
Yes
he
or
was
no,
never
please?
promised that he would see his children.
Okay. You did, am I correct, and we've watched the plea hearing here today, so you're aware of that there was a discussion about the bond at the conclusion of that plea.
Yes.
Are you aware, I'll direct your attention to what should be State's Exhibit 2 that should be sitting up there. That's a judgment entry dated September 16th of 2025 that denied the request for a bond amendment to allow Mr. Boers to see his children. Is that accurate?
Yes.
Would that have been shared with him?
This was September 16th.
That entry is dated September 16th.
Yeah, it was ruled on from the bench, I believe. I don't remember, but that entry, I believe it was ruled on from the bench, correct?
I'm not answering questions. I'm
I-
a judge here. You gotta answer the questions.
He would have been either notified of that right when we got it, or it was ruled on from the bench. I don't remember, but it was,
Okay.
I know the ruling came very quickly and he was notified.
Okay. Once notified of the ruling that's dated on State's Exhibit 2, did you, between September 16th of 2025 and the termination of your services with Mr. Boers, did you file any motions on his behalf after that date?
Not that I recall.
Did you decline to meet with Mr. Boers at any time after September 16th and prior to the termination of your services? Did you refuse to meet with him?
No.
Or did you decline to file any motions on his behalf?
After the plea?
Correct, after the plea.
No.
Did you become aware in October of 2025 that,
If I could go back to the last one.
sure,
I guess I was requested to file, he was rearrested for a bond violation. I was notified by Sheriff Sigsworth, and he was, I notified him to turn himself in, that it would be better to turn yourself in, especially considering you're going to a sentencing, it's not very good to get a bond violation. And he did request for me to file a motion to reinstate bond. I don't believe I filed that motion to reinstate bond, but the reason for that would be my representation was terminated.
okay. So apart from that, there were no other requests or motions filed by you on his behalf?
No.
Did Mr. Boers ever contact you after the ruling on September 16th regarding the bond to question you about why the promises he alleged you had made had not been followed through with?
I think we definitely had a conversation leaving the court about what had transpired in court, primarily with the statements that were made by the individuals, the individuals that the victim's advocate had brought forth. we definitely discussed what they had said because it wasn't what we anticipated was going to be said.
And based upon your interaction with Mr. Boris during the plea hearing, I'll call it on September 15th, did you ever believe he lacked an understanding of what was happening that
No.
day? Did you have any indication that he did not understand the content of the document States Exhibit 1, which I will refer to as the plea sheet?
No, we reviewed extensively what that was.
You were aware that he was interviewed by Detective Orzak from the Erie County Sheriff's Office in March of 2024.
I believe that was part of the discovery.
And would you have shared that interview by allowing him to watch it or watching it with him, that interview with the defendant?
Your Honor, to protect me, I think this is, the communications we have related to it, I think are privileged.
That's not the question.
Yeah, I was asking you whether or not you shared with him that video.
Yeah, we watched it together in my office.
Okay.
I think I might have sent him a Dropbox copy as well.
I'm sorry, Your Honor, I did not hear the last portion of his answer.
Fair enough. Repeat what you said about the Dropbox.
So I don't have my notes in front of me, but if people ask for copies of things, anything that's not counsel only, videos we'll send via Dropbox, and this paper discovery will email or hand them. But I know for certain we watched those videos in my office conference room together.
And would you have allowed him to see the entirety of the video as opposed to skipping through it and only showing portions of it?
Objection.
Overruled.
I'm not 100% sure if we watched every single second of the video together. We definitely watched, I don't know. Yeah, I guess I can leave it at that. I believe we did, but I can see the possibility that we skipped to, and there's, I guess you would understand when a police car is pulling up the first 15 minutes where
Oh, okay. So
nothing happens.
then
Let him finish.
I'm sorry.
Where there's portions of video that's nothing, where body cam starts early, things like that, or between conversations that might have been skipped.
So would it be accurate from what you just said that portions of the video that would be relevant to any defenses that you might want to formulate or any information you felt relevant to his decision about how to proceed, you would have shared with him in its entirety?
Objection.
Overruled answer.
Yes, he's seen every bit of evidence.
Oh. Thank you, Your Honor. I have nothing further of attorney.
Cross-examination.
Thank you. Good afternoon, Mr. Maguki. Let me ask you if you recall how long you were at the court on September 15th when the plea agreement was entered.
I have no idea.
Do you recall what time it was when the court went on the bench?
I have no idea.
Do you recall if you had a conversation with Robert Burrows prior to coming here in the courtroom and appearing in front of Judge Bennett?
Are you asking about the 15th?
Yes, on the 15th.
I had a conversation with him prior to coming here. Coming in, there was plenty of conversations with him prior to
Well,
coming to the court.
Okay, let me be more precise. I'm talking about September 15th and only September 15th. So on that day, did you have a conversation with Robert Burrows prior to coming into this courtroom physically to appear in front of Judge Bennett?
I'm not 100% sure, but I believe we did. I know in the last few days leading up to the plea, we had quite a few conversations.
Do you recall going into a small courtroom, which is adjacent to this courtroom on the second floor of this courthouse, and talking with my client? Yes or no?
Yes, I think we talked in there and in the hallway both, or in the area out in front of the courtroom.
And how long did you spend in that small courtroom?
I have no idea.
How long did you spend in the hallway?
I have no idea.
During that time, had the plea agreement, which is Exhibit 1 that you were looking at, that you signed, had it been written at that point?
I'm sure there was time before and after it was written. It gets written while we're here.
I appreciate that, and I understood that it was written as a collective effort of you and the prosecutor. Is that what you said?
Yes.
Okay. Who actually wrote the plea agreement?
Prosecutor Lilly, as is custom. They don't let defense attorneys write them for pretty obvious reasons.
Okay. After the plea agreement was written, did you show it to Mr. Boros?
Yes.
Did he, in any way, how long did he look at the plea agreement?
I don't recall.
Do you know if he's capable of reading and writing the English language?
He never indicated to me that he couldn't.
But he never indicated to you that he could either,
Well,
right?
he did state on the record at the plea hearing that he could.
Yes,
read and write
I understand. That's the only time he had ever said that he could read and write the English language. That was a question that the judge asked, correct?
Generally, if someone can't read or write,
No,
they
just
tell
answer
me
my
that.
question.
Okay. He made no indication that he could.
Okay. You don't recall how long or even if he read any portion of the agreement. Is that correct? The written agreement, Exhibit 1.
I don't know how long he would have read. I don't know if he read every word of it.
Do you know if he read a single?
Don't interrupt. Finish your
I'm
answer.
sorry.
A lot of it's me explaining portions of it. Not many people read every single word of it, just like any legal document. So I'm not sure if he read every word.
As you sit here today, you do not have a recollection of what you actually spoke to him about that was contained in Exhibit 1. Is that accurate?
I recall in general.
But the specifics you don't recall at this point.
I guess if you would ask me about a particular thing, I could give you that answer, but I don't know what I guess I need a more specific question.
Did you have any understanding that he understood a legal terminology?
I wouldn't have gone forward with a plea if I thought he didn't understand.
I understand. Did you ask him what he understood by proof beyond a reasonable doubt?
I would not have asked that particular question.
Would you have asked him what was meant in the law by burden of proof?
So, are you asking on the 15th?
Yes, I am.
On that particular day, I don't know if we went over beyond a reasonable doubt and burden of proof, but it's something that we would have discussed over the months that I had this case. And I'm certain that I discussed both of those topics.
Is the first time that Robert Boros was ever shown the plea agreement was on September 15th?
Physically shown, yes.
Robert Boros has contended that you told him that you would never enter into a plea agreement in this case if he was not able to see his children.
So, if I could expound, I could explain a history of the seeing the children part so you have context.
Actually, I'm not interested in your version of the context. I'm asking you whether you ever said to Robert Boros that I guarantee you will be able to see your kids when you enter this plea.
No. And
Are
I
you
can't
certain of
legally
that?
say that either. It would be unethical to make a guarantee.
Do you have any perception that Robert understood you to say that, even if that was not exactly what you said?
Objection.
Cases?
It's speculation.
Sustained. You can rephrase, but that's sustained, it's speculation.
How many times did you talk with Robert Burrows about the possibility of him being able to see his kids if he entered a plea in this case?
It was definitely throughout plea negotiations, you have various goals, as you're aware, and that was something that was very important to Robert and something that we had been negotiating along with all the plea offers that we had. So quite a bit.
Do you recall if you were present at the pretrial conference in this case on August 11th of 2025?
I believe I was here for every one of his pre-trials.
Do you recall whether or not you went in front of the judge on that day after you discussed the matter with Paulette Lilly?
In August?
August, yes.
Was that I don't recall the particular pre-trial.
Do you recall that Judge Maguki was in charge of this case until July 1st of 2025?
Yes.
And do you recall that you asked Judge Maguki to recuse herself because of a potential conflict?
Yes.
And did that conflict actually involve Thomas Duza, who was her court administrator and magistrate at the time?
Objection.
Cases?
Relevance.
I'll allow it. I overrule it. You can answer.
Yes. Thomas Duza notified me that there was a conflict.
Didn't ask that.
Okay.
I asked if it related to Thomas Duza.
Yes.
Okay? And then Judge Bennett was appointed. Is that correct?
Yes.
Was reappointed. It was now the new appointed judge.
Yes.
Did you evaluate how that process was undertaken, and in particular whether it was undertaken lawfully?
So I did not look into whether that was undertaken lawfully.
All right. There was discovery provided to you by the prosecuting attorney in this case, including paper and video. Is that correct?
Yes.
Okay. Do you recall whether any of the paper discovery was marked or designated as attorneys only?
I don't recall. It's been a while.
Do you recall whether the statements that were allegedly made by the children were marked as attorneys only in the discovery that you received?
I don't recall.
Did you provide Robert Burrows with true and accurate copies of all of the discovery that was not marked or designated as attorneys only, so he could read it, I hesitate to say at his leisure, but read it by himself at his home or someplace else, so he could understand what was being said in the case?
I want to say I did, but I can't 100% remember the moment. But I know he was in my office. We had everything together. We watched the videos. But generally, I hand him a copy at my office, or it's emailed to him if they request it.
Do you know that Mr. Burrows does not have a computer?
I don't know that.
If you emailed it to him, there would be evidence of that. Is that correct?
So there would be, but generally, so we had a lot of office meetings, and so I would have handed it to him physically, or if someone calls and requests it from my office, we email, or they can come pick it up from the office. I don't know what happened in this case, how he received it, but there was never a situation where he said he didn't have it or wanted it. I believe he had it.
Okay, but you have no recollection of actually having provided it to him, correct? I'm talking about
We
the
physically
paper,
read it together,
the paper
so he
discovery.
had every piece of information.
How long did that meeting take when you read the paper to him?
We had numerous phone calls, meetings, office appointments.
Let's talk about the appointments.
You're interrupting him again.
I apologize.
You keep saying I apologize and you keep doing it. Finish your answer.
Generally, appointments are about an hour. I have no clue how long his appointments were.
And how
Time you meet with somebody, you're discussing the discovery. I don't just make things up.
I appreciate that. I'm just asking you, it's my understanding that you sat down with him and you say that you read the discovery to him, you went over it with him. Now I'm talking about the paper discovery now. So I'm asking you, how many minutes or hours did you spend on discussing that paper discovery with Robert Boros, if you know or remember?
I know. I have no significant amount of time.
There were videos provided to you by the prosecutor, is that correct?
Yes.
Do you have a recollection of ever providing the videos to Robert Boros so he could look at them outside of your law office?
I could check my file to see if they were sent to him, but we watched them together in my office.
Mr. Boros recalls it somewhat differently. Let me see what you think about this. He said that you put him in your conference room. You gave him a large pile of paper and asked him to review it, and also to review videos that you had received from the prosecutor, which he looked at partly by himself and partly with you. Would that be accurate, more accurate, or not at all accurate?
So I believe in his case, I had something going in before I came in for the appointment. I gave him his discovery to his paper discovery to look over prior to me getting in there, so he could see it a little bit, so we'd have something to start discussing. So he would have had it for, I don't know, a couple minutes, and then I would have come into the office for our meeting. So while he was waiting, I didn't have him just sit there and wait. I handed him his discovery.
He said it was approximately 30 minutes. Would that be more accurate or less accurate than your recollection?
I don't know.
Okay. After the judge determined that the bond would not be modified so that Mr. Boros could see his children, do you recall having a discussion with him about that after the decision came down?
One that stands in my mind is right when we walked out of the court. We had discussions here and then down in front of the courthouse.
Right, I understand. I believe that your recollection could be mistaken in respect to when the judge made a decision. I believe the record shows that he took the matter under advisement and that the next day he issued a formal judgment, which is part of the evidence in front of you.
Your Honor, and I would so stipulate that there was that passage of time.
Thank you, it's
Okay,
noted
so-
on the record.
So
We're
with,
going to take about a 5-minute break to refresh ourselves. We'll come back in and finish till 4 o'clock. 5-minute break, off the record.
thank you.
Refresh yourselves if you have to. Back on in 5 minutes. Everybody be in.
Hey Josh, can you take over?
Okay. I mean, do you think you will last until 4 o'clock?
I don't know.
On national.
Well, that guy out there's been waiting for his sentencing for like, I don't think you're gonna get to him today, you might wanna.
Josh is asking right now.
Okay.
Oh, yeah, I'm not sure who's out there.
Remember when Finsworth called your lawyer and apologized for lying on national television? You remember that? I did. Finsworth called him and apologized for lying on national television, remember?
Were you there with me that time?
No, but you told me. Oh, this is fucking nuts.